Andarki Shubhodayam. Good morning to all of you. Welcome to Legal Matters by Sai Babu. We are going to discuss a consumer case. In this case, the topic is initial interest confusion test. What is this initial interest confusion test? That means even a momentary confusion is sufficient to say that the rights are infringed, the trademarks are violated. Already I told you Synthol versus Synthol. Cinthol is the original name of the Synthol company, Godrej company. Whereas people, they imitate by Cinthal, OLAL. Who will have that much of patience to look into the same? But even though if you get a confusion, momentary confusion, whether this belongs to original or this thing, and మీకు అనుమానం వస్తే itself is a synthol, TAAL చూసి ఇది కూడా ఓఎల్ ఏఎల్ అనుమానం వచ్చింది అనుకోండి, డెఫినెట్లీ ఇట్స్ ఏ రైట్ ఆఫ్ ఇన్ఫ్రించ్మెంట్, ట్రేడ్ మార్క్స్, కాపీ రైట్, ఇంటలెక్చువల్ ప్రాపర్టీ రైట్స్. ఈ మాటలు అన్నిటికీ అర్థం ఒకటే. యూ ఆల్ నో వెరీ వెల్. The matter has come before the Delhi High Court. The case law is Under Armour Inc. UA అని ఉంటుంది. యాక్చువల్గా ఇది అమెరికన్ కంపెనీ, బేస్డ్ ఇన్ మేరీల్యాండ్, బాల్టిమోర్ అంటారంటే వాషింగ్టన్ దగ్గర ఉంటుంది. It was started in the year 1960s or so. It is, of course, a popular company, even in India also. Under Armour, they are very famous for sports goods, particularly sports apparel, sports goods, like that. So, Under Armour Inc. versus Anish Agarwal and another. Anish Agarwal and another. Their company is AREO ARMOUR, AREO ARMOUR. Almost deceptively similar అని మీకు చెప్తుంటాం అలాంటి. Right. Justice Vibhu Bakru and Sachin Datta, 2 judges bench. In this case, in FAO number COMM ఏదో ఇచ్చాడు 174/2024. On 23rd May 2025, yes, they have granted injunction orders, under Order 39, Rules 1 and 2. Injunction orders against the so-called Anish Agarwal to cease and desist, to stop selling his AREO ARMOUR apparels or sports goods on the e-commerce platforms. దీంట్లో దరిద్రం ఏంటంటే ఇద్దరు ఒకే ఈ-కామర్స్ ప్లాట్ఫామ్ మీదకి వెళ్ళారు, అక్కడ బయటపడింది. కానీ దానికన్నా ముందే ట్రేడ్ మార్క్స్ దగ్గర పడుతుంది. ఐ విల్ గివ్ యూ ఆల్ ద డీటెయిల్స్, దిట్స్ బెటర్. సో it is nothing but a trademark war between Under Armour and AREO ARMOUR. Here in this case, Delhi High Court clearly held that according to initial confusion test or initial interest confusion test, a momentary confusion between the two competing trademarks, it is sufficient that the trademark infringement has taken place. Right. So, actually, this AREO ARMOUR owned by Anish Agarwal. Actually, Anish Agarwal is a pilot. He worked in Air Force. Therefore, he wanted to make it as AREO ARMOUR. He has picked up the brand. He has gone for the trademark. He has put his name in the trademark, put the trademark application. It was widely circulated because WIPO, World Intellectual Property Organization, they will display in the board. Then Under Armour people, they have seen it and they raised objection that both of them are deceptively similar. Already their trademark, Under Armour trademark, is registered. So this will be deceptively similar. So don't do it. So this man, having applied for the trademark, and before getting itself, he started selling his material, maybe the sports goods, sports apparel, like that. Right? So, and the peculiar fact is already told you, court observation. Both the companies are using similar trade channels for sale. That means both of them are going on the same e-commerce front. Maybe the Amazon, Best Buy, Target, so many things are there. Right. Here, Honorable Delhi High Court interpreted the Masha like liberal interpretation. Strict reading of the section. Section 29 of the Trademarks Act 1999 says, if the confusion arises, if the confusion comes into the mind of the consumer before consummating the purchase, then definitely the duration is not important. Even though it's a momentary confusion, it is liable under trademarks infringement. If a consumer looking at impugned marks, he gets a confusion even though for a brief period, then his trademark, the appellant's trademark is infringed. Right. So he has given all the details. UA వాళ్ళది ఇది కూడా AA ఆ మధ్యలో పోతే తీసేసాడు AREO ARMOUR అంతా ఉంది. బట్ మెయిన్ పాయింట్ చూడండి. ఇఫ్ ఎ కస్టమర్ ఆఫ్ యావరేజ్ ఇంటెలిజెన్స్, సో మ్యాన్ ఆఫ్ ఆర్డినరీ prudence, if a customer of average intelligence or imperfect collection who seeks Under Armour garment for a moment and AREO ARMOUR, he will be deceived to think that AREO ARMOUR is also same company. The test of likelihood of confusion holds good. That means it is deceptively similar. Actually, the Under Armour is a multinational company incorporated under actually the laws of United States of America. It is incorporated under the laws of USA, and their office is located at Baltimore, Maryland, near Washington already. They are operating from 1996. They manufacture and sell casual apparel, sports and allied products. Right. And this other party, respondent, AREO ARMOUR, he is also popular for clothing and footwear, and he applied for the trademark but did not get it, as objection was raised by Under Armour. Although it is pending, our man started selling. So therefore, injunction order was given. Here actually, these people, Under Armour people, while raising objection, they applied before the single judge, Delhi High Court single judge, no, it is different. Under Armour, AREO ARMOUR, స్పెల్లింగ్లో తేడా ఉన్నాయి, ఎలా కాదన్నాడు ఆయన. బట్ ఎనివే, డివిజన్ బెంచ్ ఆఫ్ హైకోర్ట్ హ్యాస్ టేకెన్ ఎ గుడ్ డిసిషన్. సో కన్జ్యూమర్ కోర్టుకి వెళ్ళే వాళ్ళు మాత్రం ప్లీజ్ రీడ్ ద కేస్ లా అండ్ ఎన్రిచ్ యువర్ లీగల్. విత్ దిస్ ఐఎమ్ కంక్లూడింగ్. థ్యాంక్ యూ వెరీ మచ్.